hybrid open meeting. The public participation guidelines are as follows. We are using Zoom for this meeting. Which allows for the public to participate in the meeting as an attendee. The chair can request that members of the public provide their names for purposes of keeping accurate minutes for the meeting. Attendees must register to participate. The registration link is unique to the meeting. The registration link can be found in the description of the Nantucket Government TV YouTube live feed for the meeting. Attendees will join in listening mode. They can click the raise hand button if they wish to speak. The chair will call on those who have raised their hands in the order they were raised to the best of my ability. All questions should be directed through the chair. As a preliminary matter, my name is Susan McCarthy. I'm the chair of the Nantucket Zoning Board of Appeals. I'd like to confirm that all the members and persons anticipated on the agenda are present and can hear me. Members, when I call your name, please respond in the affirmative. Michael O'Mara.
Here.
Elisa Allen.
Here.
John Brescher.
Here.
Mark Poor. Jim Mondani.
Here.
Staff, when I call your name, please respond in the affirmative. Billy Saad.
Here.
Nikki Sheriff.
Here.
Anticipated speakers on the agenda, please respond in the affirmative. Paul Murphy.
Here.
Okay. Good afternoon. This open meeting of the Town of Nantucket Zoning Board of Appeals is being conducted remotely pursuant to Chapter 2 of the Acts of 2023. Ensuring public access does not ensure public participation unless such participation is required by law. This meeting will feature public comment. For this meeting, the Town of Nantucket Zoning Board of Appeals is convening by video conference via the Zoom app as posted on the town's website, identifying how the public may join. Please note that this meeting is being recorded and that some attendees are participating by video conference. Accordingly, please be aware that other people may be able to see you and take care not to screen share your computer. Anything you broadcast may be captured by the recording. All supporting materials that have been provided members of this body are available on the town's website unless otherwise noted. The public is encouraged to follow along using the proposed agenda unless I note otherwise. We are now turning to the first item on the agenda. Before we do so, please permit me to cover some ground rules for effective and clear conduct of our business and to ensure accurate meeting minutes. I will introduce each speaker on the agenda. After they conclude their remarks, I will go down the line of members, inviting each by name to provide any comment, questions, or motions. Please hold comments until your name is called. Further, please remember to mute your phone or computer when you are not speaking. If you're attending on Zoom, please remember to speak clearly and in a way that helps generate accurate minutes. For any response, please wait until I yield the floor to you and state your name before speaking. If members wish to engage in a conversation with other members, please do so through me, taking care to identify yourself. For items with public comment, after the board members have spoken, I will afford public comment to those members of the public that have joined the meeting via Zoom or in person. Members of the public who wish to speak must state their names and be acknowledged by and speak through the chair. Do we need to do each vote by roll call? No, right? No. All right. Okay. And that is it for that. Thank you, Nikki. Sorry about that. Okay, so I'm going to call to order the regularly scheduled June 8th Zoning Board of Appeals regular meeting. Would someone make a motion to approve the agenda as drafted?
Second.
All right, so Michael's made the motion. Elisa has seconded. All those in favor say aye. Aye. Okay. Next is approval of the minutes from 5/11. I had a couple comments on these, just basically like editing and typo stuff, not like punctuation and nothing. I don't think I had anything that was like substantive changes, just some like capitalization and bolding, things like that for consistency. So I think unless anyone has changes or revisions that are substantive, we could probably vote to approve them. And I'll just give you my markups if that works.
That would be fine.
Okay. Any board members have any comments on the And one of the biggest, the only substantive one really, which is just that it identifies it as the minutes from April 13th, but they're the minutes from May 11th. Right. But other than that, the rest of it's just spelling and punctuation and stuff like that. Okay, so not hearing any comments, would someone want to make the motion to approve the minutes with the just minor edits to be made? Okay. All right, so Lisa's made the motion, Michael has seconded. All those in favor of approving the minutes with the editorial changes, say aye.
Aye.
Aye. Okay, so that passes. So the first thing we're going to talk about today is the open meeting law complaint from Paul Haverty dated May 18th, 2023. And town council is here on Zoom to discuss. Yes. Okay, sorry, I didn't call you out during the reading of the instructions. Who is it? Is it Janelle?
Yes, thank you. Thank you, members of the board. Janelle Austin, Town Council, KP Law. Thank you.
Yep. So do you want to talk about the complaint and the response and just explain to us the response?
Sure. Thank you. Through the chair. As you know, there has been an open meeting law complaint filed against the board by attorney Paul Haverty dated May 18th, 2023. It pertains to the Board of Appeals meeting on May 11th. At the meeting today, the board will acknowledge the open meeting law complaint against it, discuss the allegations generally. Town council has prepared a draft response subject to the board's review this afternoon relative to the allegations set forth in the complaint, which I will discuss in 1 minute. Essentially, the board will review those allegations and discuss it, determine if there are any comments to the draft proposed, and authorize town council to file the response with the complainant and the Attorney General's Division of Open Government, subject to any comments or changes the board may have. In essence, the complaint alleges that the motion to amend the meeting agenda for the May 11th meeting was not in compliance with the provisions of the open meeting law, as it was not unanticipated, nor was it an emergency. Town council has prepared a draft response subject to the board's review, outlining the board's position on that, and certainly available to answer any questions the board may have this afternoon. Thank you.
I read over the town council's opinion, and I'm sure we've all read the complaint filed by Attorney Haverty. I don't have any changes to the response. Does anyone have any questions for town council about the open meeting violation that was filed? Jim?
I do. And what was your view? Why didn't you think it was constituted an emergency?
There was discussion based on my review of the meeting that it was something that was anticipated by the board in advance of the meeting, and based on the totality of the circumstances and the factual circumstances surrounding it, and the Attorney General's determinations in what generally would constitute an emergency. In my opinion, based on my review of the open meeting law determinations on point, it is unlikely that it would constitute an emergency for purposes of the open meeting law.
Well, I mean, I disagree with that. I think there was a reason for it, and the circumstances are important. I was not able to get this item on the agenda. We had a hearing at 2 o'clock that afternoon, and we were not represented by counsel. And what's ironic about this is your law firm is writing this when it has to do with us obtaining special counsel. So you you're conflicted on this. And that's been the basis of what I've been saying all along. You're throwing this board under the bus by saying, yeah, we violated it. And I think there's some meritorious arguments that you can use. One, the emergency. And two, and this is something that I know the AG's office has ruled on, we could have ratified this at another meeting. But again, the chair has refused to allow me to add this as an agenda item. So that's that. My other question relates to, why don't you just have us ratify the vote? Why don't we just go and open it for discussion and ratify it? And my concern is that you probably have a conflict in that, and probably a concern because we're going to reopen this to appoint special counsel. And I guess the bottom line is, I don't think it's an acceptable response. And I think the board should consider that and consider some other options and review the draft, which unfortunately we don't have at this meeting because
The draft of what?
it wasn't included in the packet.
This,
Yeah,
well, it was sent to us.
I know. I have it.
Okay.
I have it here. But it'd be nice to have it in the packet.
Okay. So then can I ask a follow-up question? What are the consequences of acknowledging that there was an open meeting violation for this board?
Thank you through the chair. And just to be clear, the response that's been provided to the board is consistent with my experience in interpreting the open meeting law. And that's what I'm here to discuss this afternoon. In my opinion, the consequences are as follows. Generally, if a complainant is unhappy with the board's response, they would seek further review with the Attorney General's Division of Open Government. To the extent the Division of Open Government may deem it to be a violation of the open meeting law, there are often remediation requirements, training requirements, or alternatively, if there's an intentional violation or a series of intentional violations, there is the risk of penalties or fines in extraordinary circumstances.
Can you answer the questions that I asked?
Can you?
Do you believe that your firm has a conflict in this?
Jim,
and do you believe that emergency?
Jim,
I asked questions.
I heard you, but I'm not going to have this meeting harangued and taken away. So try to just follow through me to her.
Okay.
So Jim's asking if you can address the questions he had about what conflict.
Yeah, whether they have a conflict, because that's what this was about. And two, what about the other options that we in an open meeting, we shed light on it. So this isn't your typical open meeting violation. It's an agenda violation. It's not like we discussed this behind the scenes. And I think this is something that we can readily rectify by putting it on the agenda and discussing it and revoting. That's fine. And maybe it doesn't require a vote, but I feel like town council is not adequately representing us.
So okay. So Jim has those questions, and I guess I would follow up with that question saying, is that an option that the Division of Open Government and Attorney General's office allows a board to then open or go back and vote? But it's still not, we would still need to do that in July. I mean, it's still not something that's on an agenda. Right, but is that another avenue that the board could pursue? A viable avenue for rectifying a potential open meeting violation?
Thank you. And through the chair, first, just to be clear, it's certainly our position that there is no conflict at issue here. And second of all, I want to be cognizant of what's on the agenda this evening or this afternoon relative to just discussion of the open meeting law complaint at issue. So I want to be clear about that. With respect to the second question, in terms of the potential remedy, in my opinion, there is an option to have a meeting subsequently if it's posted in accordance with the open meeting law, if the chair so declares, to put it on the meeting agenda as a topic with 48 hours advance notice to resolve it as well. In response to this complaint, as you all know, there's a 14-day requirement to provide a response to the complainant as well as the Division of Open Government. That is what we're here for this afternoon, but that is an available remedy to attempt to ratify any open meeting law violation under the Attorney General's determinations.
Does any of the other board members have any questions, Michael?
Didn't we vote whether or not to seek out our own counsel?
We did, and we voted. That vote did not carry.
Correct. So if I'm not sure if that's ratifying the situation or not, but I would think that that's got to fall into this puzzle somewhere that we did vote on.
Yeah, I think that is mentioned in the complaint, that the potential open meeting violation, the way that I read it, not that it's mitigated, but that the fact that the topic of discussion, the topic of the open meeting, or one of the, this is only, I think, one aspect of the complaint that was filed, but that it wasn't voted forward, maybe tempers the violation, the potential violation.
I have one other question.
Sure.
If the member thought that it was an emergency in his mind, and maybe still feels that way, maybe he doesn't, is that clear-cut evidence that the open meeting law was broken?
For you, Janelle.
Thank you, through the chair. So generally, in my experience, the Attorney General's office would look at the totality of the circumstances to determine whether based on the law and facts at issue, this would constitute an emergency. As you might expect, emergencies under the open meeting law generally pertain to public health and safety emergencies, large storms, sewer issues, certainly public health emergencies in the past couple of years. Those are generally the categories that fall under emergencies for purposes of the open meeting law. Even if it is an emergency, what the Attorney General's office advises is that the best practice, so to speak, is to amend the agenda as soon as possible to give members of the public as much as advance notice as necessary, to revise the agenda as soon as you can, even if there isn't an emergency, and then to ratify it at a future meeting if the chair decides to put it on the agenda. Thank you.
Last question.
Sure, Michael. Yep.
One last question. What are we going to be voting on today regarding this?
Thank you. Essentially, all the board is being asked to vote on is a response to Attorney Haverty's open meeting law complaint that's before you. Town Council has prepared a draft for the members' review this afternoon. A copy of that has been distributed. So essentially, it's just a motion to authorize the draft subject to any comments or other considerations the board may have, and to authorize Town Council to file that with the complainant as well as the Division of Open Government in response to the May 18th open meeting law complaint.
Mm-hmm.
Thank you.
Thank you.
Madam Chair,
Yes, Jim.
just for the record, and I'm not sure council knows about this, but I requested after that one, I acknowledge that if it was deemed a violation, that we could have ratified at another meeting. And I just want to put it in the record that I requested this agenda item and it was rejected. So those circumstances need to be taken into account. And in our council's representation of us.
Okay. I have one comment to make about the emergency. When we were discussing this and when the request was made to the motion and an emergency notice or emergency aspect of it. It was not brought to my attention until later, and it's in the minutes on page 8, but it was not brought to my attention and maybe the board's attention in general that the hearing that was on that day at 2:00 or 3:00 was something about for the land council and tipping point to introduce additional evidence. And the town wasn't really a participant in that hearing. So I feel like if we did have any emergency aspect of it, it kind of, once that was made known, if that had been made known at the beginning, we might have gone down a different path, but that's neither here nor there, but just putting that out there. I support the recommendation from town council. I don't have any changes to it. I suggest that we acknowledge this response and authorize town council to file it with the Attorney General and Division of Open Government to meet the 14-day response. Unless anyone has any suggested changes or other questions or comments. No. Okay. So would someone make that motion, or I can make that motion to accept this drafted response and authorize town council to file this with the Attorney General and Division of Open Government? Want me to make that motion? I'll make the motion. Would someone second? Okay, Michael seconds. Okay, so we'll do, we don't have Lisa, so we'll do, Jim, we'll do down this way. So Elisa down. All those in favor of acknowledging this and authorizing town council to file with the appropriate agencies, please say aye. Aye.
Aye.
Okay, so that's 4 and you're a nay, Jim.
Oh, yeah. I didn't know I was voting. Nay.
Okay, so 4-1, that carries. Okay. Please let us know, Janelle, if you need anything else from us regarding if anything else comes from this.
Thank you, I will, and I'll make sure that the board has a copy for its files as well.
Okay, wonderful.
Thank you very much.
Yep,
Thank you.
Thank you for your
Thank
time.
you for your time. Thank you.
Okay. So next on the agenda is old business 37-21 8 Bank Street. They have requested to continue until the July, I don't know the date. Is it July? Is it the week of the 4th of July? July 13th, sorry. July 13th. So they've requested to continue to July.
May I just interrupt for 1 second?
Sure.
And go back for a second. I'd like to just request in the future a document this important should be included in the packet. I did read it online, but I think something like this that we're voting on should be printed and included in the packet. What
Okay.
were we just talking about? From KP Law. I didn't get was that included in the packet though?
I mean, I printed it when I got it, so I would have it, so I could.
Yeah,
read
I
it
just-
before the meeting.
Okay, just a request.
Okay. Okay. Sure. Yes. Today we were supposed to review and vote on a draft decision. Which was not, the decision is the one from last time. I had a question about that because it wasn't in the packet, but I got notice that the applicant has requested to continue until July for us to review that.
Yeah, so
Decision.
the decision I've included in the staff report.
Oh, sorry.
I attached it at the end of the staff report.
And it's the
just
same,
review.
version that we had
Yes,
Yeah.
with some minor edits from directly after the meeting.
So I don't see the applicant here, but they've requested to continue until July. I don't have a reason from them.
Do they have anything new to present to us, or are we just voting on the,
We are
what's been
just,
written up?
we're just voting on what's been written up. Unless there were additional questions or comments about the conditions or the decision.
Are they going to be adding anything new? Is
I
that
don't
why they
believe-
wanted to continue?
I
it?
don't,
Why can't we just vote and get it off of our plates? Why they could continue it for a year if they don't, there's nothing new.
What's the when is
reason?
there?
What's the reason that?
Oh, we also have to agree, their action deadline's June 22nd.
And that's
Did-
what they did.
did they agree?
Sign an extension when they requested the continuance.
I don't understand what the purpose of the continuance is, though. I just keeps turning up. And I don't know if there's.
Did they give any reason?
Not to me. I mean, I was under the impression that, because I had the same questions when it was posed to me, and it was explained to me that it's just been the practice of the board when an applicant requests a continuance that the board grants it.
How long has this application been in front of the board from the very beginning?
For a while. It's been over a year, I think.
Can I make a motion not to continue it, to vote on it today?
You can, but I agree with Billy that it has been the practice of the board. I can't remember a time when an applicant has asked to continue and we have not.
Well, don't we vote on it anyway?
But for what?
We vote on the continuance. Yeah, we do. But I'm saying,
I see. How many, do we know how many times this has been continued or delayed?
I have not counted
say
that.
Is it over a
year.
year?
I think it's over a year and a bunch, some delay was on our end and some delay was on their end for
Mhm.
sure. I mean, and waiting for.
But we're not waiting on anything anymore, right?
I don't think so. I would think they would want to have the decision done since I feel like we're like right on the goal line with this. But again, I don't.
So I wonder what they're expecting by continuing it. What different outcome than what we would vote on today, what we would be voting on in a month.
Madam Chair.
Yeah.
if I may, I don't know. My guess would be that because Lisa isn't here, they want a full board.
Yeah,
Oh,
Would be my,
okay.
because otherwise it's
because
just.
otherwise it's four. I can't mull in. I don't think Mark can either.
Mm-mm. Yeah,
Were they
But will Lisa
aware
be here?
that Lisa was not going to be here?
no, I don't think
No,
so.
not to my knowledge.
So
But will Lisa be here or will they just continue forever?
No, I don't think they'll continue forever.
I mean, I'm
I
being
think that would
sarcastic, but-
be, yeah.
I just wonder what the reasoning is. Like, this is precious time that they're taking up now,
Well, yeah, but we,
continuing
right,
for no reason.
right. I agree, but now I don't want to waste our time.
Okay,
Postulating about why they did this.
right,
And
okay.
I can't remember a time we
Is there
haven't.
counsel here?
No, no one's here. I don't see anybody. So I think we should move on.
Okay,
Yeah.
Let's say 80% now, 60% of the time, we don't know why.
Yeah.
but it's usually because they owe us more information or someone on their team owes information, but we've heard.
No,
Every
sometimes
single
it's
thing.
strategic. If there's like,
could be
if it could be for
tactical.
anything that people
Mhm.
request for a lot of different reasons. So.
Is there any important deadline that is going to be
No,
passed
the
by?
only deadline that was just this action deadline of June 22nd, but they signed an extension because we don't want to have a constructive grant.
Right.
So,
And I bumped that extension out to September 30th to give us some breathing room if
Okay.
anything
Okay.
happens.
It's gonna be board's gonna change a little.
Yeah.
next week.
and then
And
we'll
they
have to,
won't be able to mull it in, right? The new people?
we'll have to address that. I don't know. They'll have that. I mean, that's the risk they take by continuing. So, let's move on.
Okay.
So would someone make the motion to allow this to continue to July 13th, 2023?
I'll make that motion.
Okay, would someone second it?
Second.
Okay, so Michael's made the motion and John has seconded. Let's see, sitting on it is me. Me, actually, John, why don't we have Elisa second it? Because you're not sitting on this, so.
I withdraw my second.
Okay, would you second?
No,
Okay, then I'll second. So sitting is me, Lisa's not here, Michael, Elisa, and Jim. So it's gonna be the four of us voting, so. All those in favor of allowing the continuance, say aye. Aye. All those opposed, say aye or nay.
nay.
Okay, so we have two. So where do we go with that?
Mhm.
That I'm not sure of.
I don't know the answer to that. Because I don't think we've ever had 2-2. Yeah. Not that I can remember.
I mean, it seems like you can get another board member to vote. Right?
Well, if you have a sitting board, I don't think you can.
It's not like a substitute.
But you have a sitting board, so if then you voted and you haven't mullened in,
I think that the 2-2 vote doesn't carry.
yeah. I think you're right.
Would you like to hear from any of the legal intelligence?
Do we have any?
No. Yeah.
God, after the last month, I need like a Robert's rules, like crash course.
The only thing we need to remember from Robert's rules, usually, chairman's always right.
I wish that worked at home too. That's great. So we'll wait for Nikki, I guess. I don't know what she's doing, but yes.
I'll reconsider my vote.
Okay, so do we need to Billy, do I need to do another motion?
Yeah,
Okay.
I would make another motion because that didn't carry at 2-2.
So then we'll have a new motion to grant the continuance as requested till July 13th, 2023. Michael, would you make that motion?
I will.
And I'll
And
second.
I'm only doing it because Lisa's not here and I'm, I feel like she could be here about.
Yeah. Okay, so
I'm
So-
not so sure that would be.
I'll
well,
second. I don't want to get into ifs. So Michael's made the motion. I'm going to second and we're going to vote again. So it's myself, Michael, Elisa and Jim. All those in favor of granting the continuance, please say aye.
Aye.
Aye. Okay, so now and nay.
Nay.
Okay, so 3-1. Okay. All right, so you can move on and away from that. Okay, the next one we have 922. This is 50 Weweeder Avenue. They have also asked to continue to July 13th, 2023. Can I do all of these together? And 2022, 29 Monomoy Road Nominee Trust, and 1022 4
Okay.
Washington Avenue.
You could do the old business.
Old business,
together.
sorry. Okay. All right. So 922 and 2022 have both requested to continue to July 23rd. Would someone please make a motion to grant those requests?
Sorry, I didn't hear what the numbers were again. No.
So it's 922.
Yeah.
And 2022.
Oh, okay, got it, yeah.
Okay. So those two have also requested to continue to July 13th, 2023. Would someone make the motion to allow that continuance?
So moved.
Okay. Would someone second?
Second,
Okay, so. No, sorry, guys, I'm gonna separate those out because we have sitting boards on those, sorry. So, 1, 2, 3, Actually, it doesn't matter. So all those in favor of allowing the continuance, it's going to take 2, 3. I'm going to separate them out. Sorry, because there are sitting boards. So for 922, it's 50 for 50 Weweeder. Brusher, you're conflicted on this, obviously. So it's myself, Elisa, Michael, and Mark Poor. All those in favor of allowing the continuance, say aye.
Aye.
Okay, so that is granted. The next one is 2022, which is myself, Elisa, John, and Jim. All those in favor, say aye.
Aye.
Aye. Okay, so those two are, okay. Now for the new business, 1022 4 Washington Avenue, would someone make a motion to allow that to continue to July 13th, 2023, please?
So moved.
So that's John. And would someone second?
Second.
And Elisa seconds. Okay, so we'll do 1, 2, 3, 4. We'll do 4 over to Jim. All those in favor to allow the continuance, please say aye.
Aye.
Okay. And then 1722 Nantucket Cottage Hospital has asked to withdraw without prejudice. If someone would,
So moved.
Elisa makes the motion for a second,
Second.
and John. Okay, we'll vote this time. Let's vote from Mark. You want to vote on this one?
Sure.
Okay, so we'll vote from Mark over to John. All those in favor of allowing the withdrawal without prejudice, say aye.
Aye.
Aye, okay. Mhm.
Yes.
Oh,
Yes, okay, so now we can move on to new business 0623 to Nobadeer Way, Attorney Cohen presenting.
Thank you, Madam Chair, members of the board. So this property on Nobadeer Way, you probably mostly know, is this U-shaped road across the street from Airport Gas. If you're just for give you the geography of it, and it has on it a 3-bedroom home and a 1-bedroom cottage. Both of those are occupied by year-round families, and my client is a landlord that provides that housing for those year-round families. The condition of those properties is not very good. My client would like to build a new structure on the property. The problem is you can't get a building permit for a new house if you have the house on the property, because it would exceed the number of allowable houses on the property. What my client doesn't want to do is displace a local family with children that are year-round and have them out of the house for a year or more while we're doing construction. So what my client is asking for is a variance from the definition of dwelling, which a dwelling under the Nantucket bylaw is defined as a structure that is either occupied for or intended to be occupied for dwelling purposes. And then it has, other words that say what that means. But essentially what I'm asking for is for the board to give a temporary waiver of the phrase intended to be. So that in other words, this structure would only be counted as a dwelling when it is occupied, not when it is intended to be occupied, because the intention starts with as soon as you dig the foundation. And so that temporary variance would only be through the construction of the structure. The family would move out of the very poor condition building into the brand new structure, and then the waiver would be extinguished by the operation of the permit they're requesting, and the existing structure would be demolished. So the property would always be in compliance with the number of occupied dwellings on the land at the time, and we would only have that allowance. So the purpose here is not to create some windfall for my client who doesn't, from his perspective, what he's trying to do is not displace a local year-round family. And so he's asked me to come to see if we can get that variance. I'm happy to go into more details, but I think that generally covers the concept. I would note one other thing, that I know that the staff report recommended against this because in general, you're not supposed to give use variances. I don't think this is properly characterized as a use variance. I understand why the staff made that point, and I think they were actually diligent about it. And in fact, I think the way I originally applied for it, they were correct, and I had to change my application based on some advice and dealing with the staff to give a different reason for it. I had originally asked for an additional dwelling, which I think would have been a use variance that you couldn't grant. I would note that the board has granted similar relief to what I'm asking for in different purposes. And what I mean by that is, right now, you can get a variance or a special permit relief from the definition of tent to allow it to be on the property for more than what is otherwise allowed under the definition in the bylaw. I think you guys know that they're allowed for so many days per year. And the bylaw was changed to allow for that special permit, but prior to that change, it was a strict, you can only have a tent for so many days. And both the Dreamland Theater and the White Heron Theater were built with tents that occupied those properties for more than 2 summers each. I think one was 2 summers and one was 3 summers, in which they effectively ran the whole operation through a tent that was far in excess of otherwise allowed under the bylaw. And what the board did was instead not allow a use that was unallowed, but allowed a use that was allowed for longer than would otherwise be allowed. And it was actually because of those 2 situations that the board requested that the planning department put in a warrant article to allow that to be done by special permit, which is now. But at the time those permits were granted, they were both granted under variances. So that is the model under which I'm suggesting this here, that it would be a temporary waiver of the intended to be occupied language to allow for an unoccupied structure to be built until such time as the people could move from one building and another building, and we demolish the other one, and nobody has to be displaced. Thank you.
Madam Chair. Can we hear from Paul, the head of the building department? His opinion on this? Was it his recommendation to not grant this? Is he, hi.
Paul Murphy, building commissioner. I didn't weigh in on this one way or another. I don't have a position on the matter, whatever the pleasure of the board is.
Have you seen this? Sorry, have you seen this in the past?
Not on Nantucket, but in other communities.
So you haven't seen yet where one house is going up while the other one is occupied and then that gets demolished? And
I have not seen it on Nantucket, but I've only been here 4.5 years, so
gotcha.
Okay. Don't have a long history with it, but it is done in other communities. So yeah, just wanted to make that point. Thanks.
Okay, thank you.
Sure. Michael, for 1 second, Elisa, just to answer your question, my understanding, and it predates my personal experience, but I know Bernie Bartlett, who used to be the building commissioner, used to allow for these types of permits with conditions on them for people to move houses and otherwise engage in the construction or moving of structures to properties where they were going to build something and then demolish. And the problem he ran into is he got burned by people who would not finish it and whatever. So it's been since, I mean, Bernie's been gone for a while now, but it's been the policy of the building department, as far as I know, that because they got burned on it a few times, they stopped doing it. So, and I should also say, just while I'm on it, that my client would be definitely willing to put money into escrow or otherwise conditions in place that would assure that this would happen. We're not trying to do anything except preserve housing for a family. Michael.
How close the new construction be to the old?
It's
Physically, so this is an oversized lot. It's 10,000. It's a 15,000 square foot lot in what is otherwise 10,000 square foot zoning, and the plan shows the houses, and the plan, I believe, has a 10-foot buffer around it, so that might give us some scale.
Look to me like it's 15 feet or less.
Those, I think that's the existing structure. I think the new structure is more than that.
Well, from the existing to one of the new ones.
Yeah, so the middle structure would be kept, and it's the one demolished. So the one in the front is to be raised, and the one in the middle is to be built. And the other one is back. So yeah, your estimate might be right.
Is there any provision to put a fence around the construction until you'd be willing to do that, I assume?
Yeah, whatever conditions the board felt reasonable, my client would be willing to accommodate.
And you would be willing to put in the decision that the applicant will not come back to this board for a variance on the old
Yeah,
building,
that's fine.
other than the temporary variance?
Yeah, we would certainly accept that condition. The only reason why we wouldn't demolish that building is if someone wants to take it under the
Understood.
move off provision, but otherwise our intent is to demolish it.
Was there, Steve, was there any other, like, was there any other avenue that you, other than, you know, a temporary alteration of the definition of dwelling unit? Like, is there, because I don't love that language.
Mhm.
But is there,
Well, I had originally applied for permission to do a fourth dwelling instead, a third and fourth dwelling under the bylaw. And staff contacted me and thought that that might be a bridge too far, and I didn't disagree with their, you know, reading of it. And I think that what I suggested in the alternative was at least consistent with the practice that the board has used a couple of times in the recent past in terms of how to work within its authority.
Mhm.
You know, I don't know if the only other way I can think of doing it is to apply for a building that is not a dwelling and try to build it out. But then you also have the situation where you're, you know, at some point you need to convert those, and you still run into forcing people out at some point. It closes the window or narrows the window, but it doesn't close it. I think it would be difficult. And frankly, my client just wanted to do it as on the up and up as possible.
Mhm.
I have
Okay.
another comment.
Sure.
Question. Is this going to be a modular or stick built?
I
Structure.
believe it's intended to be stick built. Yeah, I know it's intended to be stick built.
Can we put a condition on it that the new structure doesn't receive its CO until
The other one's demolished.
the other one? Well, then the family will be like standing out in the street, so I don't want to do that.
We could certainly have a condition that made those contemporaneous.
Yeah,
I'm not-
issuing the CO, sorry.
Sure.
Is there already or you can't get the permit to tear it down right now?
No, I think I could.
Good.
We could get a demolition permit in advance of the building permit if that was something you were thinking of.
Yeah.
Has the HTC approved it?
We haven't applied for it, but the building's from the 60s, so I tend to doubt that it would be an issue.
Okay.
Madam Chair,
Sure.
is there a lease in place with the existing tenants?
There is, yeah. My client uses 1-year leases.
Just want to make sure the hardship isn't the
Yeah.
landlord not getting money in this.
Hmm.
No, I mean, it's not about the rent money. It's really about the family. He intends to move the same people into the unit. If he was, otherwise he was going to displace them. He just displaced them.
As long as we could get some kind of in writing assurance that as soon as the family moved into the new structure, the other structure had to be demolished, which I just don't know the best
Yeah.
wording to get the CO for the new structure and be sure that the old structure gets demolished and the foundation goes away and it gets filled in properly.
So I do have a thought on that for your consideration, which is that you could put a condition in it that through staff or through the building commissioner that we would provide evidence of a permit for demolition, evidence of a contract for that demolition, and evidence of availability of a date for that to happen.
Or within 30 days.
Yeah, that it could be within 30 days.
Uh-huh.
I'm sure we could make that arrangement.
Can you talk to me a little bit about next steps with the planning board for the additional bedrooms in the if you get additional bedrooms in the tertiary permit,
Yeah,
and then what's going on with the cottage?
sure. So there's 2 permits that are required from the planning board. One of them is for a tertiary dwelling, which just always needs a permit, whether it's a tertiary permit or a tertiary special permit, you need one either way. So that's something that we have applied for. It's on the agenda for Monday at the planning board. And then the second thing that we've applied for is for to exceed the bedroom count. This is allowed 7.9 bedrooms, and we've asked for a waiver to go to 8. So if that's granted, we'll go to 8. If it's not, we'll do 7. And then there's an addition that's been proposed that comes forward of the building. So it's away from the setback encroachment. We're not We had originally considered doing a sideways addition, which would have required relief from the board to do an expansion of a pre-existing non-conforming use within the setback, and then we decided to not continue with that request. So any addition to the building that's being kept would be outside of the setback.
And I see, Madam Chair, the
Mhm.
sheds. Let's talk about the sheds for a
Well, they're
minute.
gonna move.
Yeah,
All sheds are coming out of the setback?
They're,
yeah, I believe they're all in the setback now, and I
They
think
are.
they would all be either demolished or removed from the setback.
So, I don't know what that, I guess that's a stoop on the
where the
east.
landing.
East, where's this landing? I guess that's probably a landscaping, which is allowed in the setback, I'm guessing.
Yeah.
So with all the sheds out of the setback and with the front, the old structure gone and the new structure in place, will this entire property be in compliance with all of the building and planning and zoning and everything rules?
There's one nonconformity that would not be cured immediately, and that's the retained cottage is within the rear setback.
Mhm.
However, a warrant article was adopted, I believe, 2 town meetings ago to yard sale the land behind this land. So when that yard sale goes through, it will move the setback, and then that will become conforming as well.
Gotcha.
So
Thank
the
you.
only conformity that would exist is planned to be cured through that process.
Thank you.
Okay.
It would also make the lot nearly double the minimum lot size requirement.
Will there be more footprint left on this lot?
Oh, yeah, we're not building it out remotely to the available ground cover. But the number of dwellings would be used up.
Got it. Thank you. Mhm. Right.
Does anyone else have a question for Steve before I ask if there's anyone in the audience?
Not yet, Madam Chair.
Okay.
Still mulling this one over.
Okay. Is there anyone in the public that wanted to comment on this one? If you can just come to the microphone and identify yourself, please. No, ma'am.
Hi, Madam Chair.
Hi.
And everybody else. I just was reviewing this because I did.
Amy, can you just say your name?
Yep. Oh, sorry. Amy Manning, 7 Nobadeer Way, Nantucket. I was just looking at the abutters who got information, and I'm at number 7 and didn't get any information on this. There are 3 rental properties on our road. One is number 1, obviously number 2, which is what this is about. And then next to me, the house is still owned by the people, but now other family is in it. All the houses are old ranch style houses on the cul-de-sac, the horseshoe. And it was made R10 limited at town meeting prior. And so when I started hearing about this through other people, the fact that they want to do, there's already 2 buildings there and a bunch of sheds, yes. And they should be definitely the health board should go in there. The fact that they want to do, if I understand this, because I don't have all of this stuff that he did, because it wasn't sent to me as an abutter, but it's a duplex. I would think 8, you're saying 8 bedrooms, which in those houses already, if it's set like mine, are only 3 bedrooms. In the back cottage is, I don't know how many, but there's at least 6 or 7 people in that house. And there's at least 10 cars that park, 2 in the driveway, 3 on the lawn. 1 car was just removed that was in an accident and has been there since the accident. There are people that park on the road. So you want to build another house and put it in and have how many employees that work for whomever building a house, adding to our road for parking, taking away parking from what the cottage in the back is. There's already a nighttime thing where there is not supposed to be parking overnight. And technically that resource officer is going to start ticketing yet again to get that started. It's too much. Every house on there is like a 3-bedroom home. There are only 2 houses that put in technically a second dwelling. And that would be the Gullies at number 5. And then I'm not sure of Maya's last name, but our other neighbor, and they went up. There's only 2 buildings. Then you just mentioned something about the front house being lifted, which isn't even another thing. So you said something about lifting. So I'm not really sure what that's about.
Correct. I said
Mhm.
raised, I meant demolished, not RAZE,
So,
not RAI.
so the cottage that is in the back, which holds,
Do you want to see one of these plans so you can see?
so that's being demolished and the front house is staying where it is?
The other.
No, opposite. But here, we have an extra one if you want one, Amy.
A question.
Sure.
How far do you think you live from the proposed house?
Well, the gentleman, you come in, it's number 1, goes 2, 3, 4 up. I'm number 7. I'm up at the back. John Daly's number 6, and he got in a butters notice.
Is this-
My neighbor at number 8 got in a butters notice, but not me at number 7.
Do you think you're closer than 300 feet or closer?
I believe, yes, I am, because I'm right across from John Daly and Myra technically next to me. I'm the only house that didn't get anything.
Yeah, well,
Are you in the corner, Amy?
I'm number 7,
Yeah.
yes.
I think you're just outside the 300 foot, but
And I'm here, I'm definitely here because unfortunately I'm losing a good family in the neighborhood is selling. And they would be here definitely raising argument too. I tried to talk to some others. I know that there's some person, it isn't, the neighborhood has older homes and that's great. We went in for R10 limited so we can stop having 8 bedrooms. That's how many people? That's 16 people. How many cars is that? Like we don't have up at our end any parking on the island. We block that so that people don't use it. Number 1, number 2, number 3. I have pictures and shows what the lawn island that the town owns looks like. Then I have pictures of how many cars are actually already on their lawn already that they're using. There have been complaints. I've met the guy once, but we have called the Board of Health because there is illegal cooking and being sold over at Statue Park for food. It's fine, they don't want to displace a family, but there's only one family I see and the rest are a bunch of painters and different things. I get it. I don't want people to lose their housing. Housing is horrible here. But you cannot put a 3rd dwelling that's already there and say, oh, you're not going to take away, but you're adding a duplex. And I realize there's some emergency, something that they can come in for 3 years, but you can't add 16 people. And where are they going to park?
So I want to clarify.
I'm sorry.
It's okay. So it's not an emergency thing, that there's a zoning freeze that happens if you before the warrant, correct me if I'm wrong, but before the warrant is published, if you have a plan and that plan gets approved, then it has a certain amount of time that it's grandfathered or that it's allowed to use what was in existence when the plan was approved. I think, and then the duplex thing, you specifically called out that it's not a duplex, it's
a tertiary dwelling attached to a second dwelling, which under the bylaw is different, even though it's essentially
the same, right?
Yeah,
So
you're correct.
one structure with 2 entrances, but
Right.
not a duplex.
Right. It's a 3-bedroom / 2-bedroom structure with 2 dwellings in it, but technically under the bylaw, it's a second dwelling with an attached tertiary, not a duplex, which are 2 different things under the legally.
Right, because you couldn't have an existing 1-story dwelling and then have a duplex, right?
You can't have a duplex or tertiary under the current
Zoning,
but the tertiary is pre-existing non-conforming
Right.
under the zoning freeze for the prior district.
right? But I mean, under the zoning freeze of the prior district.
That's correct.
You also couldn't have a
That's
single family with a
Yeah,
duplex, right?
duplex isn't allowed in either district, but
Right.
tertiary is allowed in the prior district.
So how many, sorry. So you're adding 2 bedrooms to the property in total.
Yeah, so let me think about this for a second. So right now, there's a 3-bedroom house.
Yeah.
That would essentially have a 3-bedroom with a 2-bedroom attached to it.
Yep.
And then there's a 1-bedroom cottage, which I think frankly is actually used as a 2-bedroom cottage, that we would legalize one of those bedrooms.
Okay.
And if the planning board allows, add a 3rd bedroom. So it is planned to be either a 7-bedroom or an 8-bedroom, depending on what happens at the planning board. And when.
Okay.
If I
So-
could just-
So sorry, just yes, in a second, but I just want to,
Sure.
so the existing 1-story dwelling legally is 1, but you think is being used as 2 and may go to 3.
Yeah.
The 3-bedroom one's going to get gone, and then there's a 5. So you're adding 2 bedrooms here and maybe, so you're adding between 3 and 4 bedrooms to the property in
Correct.
total. Okay.
Yeah.
Okay.
So I appreciate what Amy's saying. Some of it is not necessarily relevant to here, and some of it actually is concerning to me as the attorney for the owner. And I'd like to follow up with her after to make sure that if there are any health and safety issues or any zoning violations or just any neighbor disturbances, my client would take action to try and mitigate any of those things. My client likes to have, nice, quiet, compliant properties. So, outside of that, what we're talking about doing here is adding changing a structure that is roughly 900 square feet into a structure that is roughly 1,100 square feet. It is not a big, massive expansion of that structure, but it's turning it into 2 dwellings. The rear cottage is only getting a couple of 250 square foot addition. They're both of the expansions of these buildings are very, very small. Both buildings would be roughly 1,000 square feet. One slightly more and one slightly less. I think on Nantucket, that's very modest, and it's also modest in keeping with the neighborhood. By right, my client can do the tertiary as an addition to the 2nd dwelling and the addition to the cottage, and it could actually do 2 or 3 times the amount of ground cover we're proposing. So everything that we're proposing can be done by right and needs basically no permits from anybody, building permits or whatever, except for the fact that we are trying to not displace that family. So if you were to turn us down, all of this would happen anyway, except we would demolish the structure first and displace the family, and you'd end up with the same exact thing. So, I appreciate what Amy's saying, but really the only question in front of you is whether you want us to demolish that building and displace the family, or if you're willing to put conditions in place to allow it to happen, what I suggested before. Everything else is by right.
Madam Chair, so go ahead.
Well, Madam Chair, may I?
Mhm.
Through, if I may, Stephen, the question before us is if we should grant a variance, not if we should displace a family.
I point well taken.
Good.
But I shouldn't put it that deeply in your lap. I appreciate the distinction.
My sense, for what it's worth, I don't love this as a variance. I truly do think it's a stretch. I appreciate that you can absolutely do this by right. And I understand why you've come before us. I would love if there was a way that you could do it administratively without a variance. Because I feel like if we go down the variance route, we're going to wind up putting a lot of very difficult conditions on this in terms of ensuring the number of occupants that, whether, again, as you said, whether it be an escrow, I'm not sure what those conditions would be or are, at least in my mind, but
Yeah.
I think they would be onerous.
And to the extent if the board were to go in that direction, frankly, it's okay for my client. I've told them to expect, conditions that would be both protective of the families on the property and protective of the neighbors. It might actually be better for the neighbors if the board put conditions in place. So, for example, a requirement that there be no on-street parking by the construction company is not something that you could do. Not something that would exist outside of outside of variance, but it's something you could put on your permit. Like there are conditions that you could impose that would be beneficial to the neighbors that don't otherwise exist.
Madam Chair.
Yes.
It sounds like there's a parking issue even without the construction vehicles.
Yeah. Our intent is to alter the parking. Right now, there's 2 different driveways, and one of them basically has all the parking in the yard. And so we are going to change that so that there's only going to be 1 curb cut instead of 2, and 2 different, modern, approved, compliant parking areas.
So I see the parking, the driveway that you're talking about, which is basically where the new structure is going to be going. And then I see a small parking area in front of the dwelling that's going to be demolished. But why isn't the new parking that's going to accommodate all of these cars that belong to all these people? Oh, I didn't see that one. Okay, here we go. But still, so that's 1, 2, 3, 4, 5, 6. And if there's going to be 3, 8, 9, 10, 11, there's 6 parking spots proposed for 11 bedrooms.
No, 8 bedrooms,
You were gonna have 3 in the back,
3,
Mhm.
3 and 2.
3, oh, excuse me, right? No, 3 plus 5 is 8.
Yeah, eight bedrooms.
sorry,
6
you're
parking
right.
Spaces,
Mhm.
which I believe is more than is required under the bylaw.
Okay,
And we could do more too. My client would have no concern with a requirement to provide additional parking if the board wanted that.
okay, thank you for this. And can we discuss why the staff recommends we don't approve this?
Sure. Can I ask one question first on the plan? So Michael, I may be asking what you asked at the beginning, but the proposed addition
Oh.
on the existing one-story dwelling
Yeah.
and the proposed dwelling with the attached tertiary do you have enough? I see it looks like there's going to be a split rail fence or whatever, or perforated.
That's the 10-foot buffer that surrounds the building.
That's what I was going to ask. Do you have enough
not a
with that addition? Is there well, it says here, I wrote over it now, but it says proposed fence, but is there enough, do you have enough space between those two buildings?
For the 10-foot rule?
Yeah.
Yes,
All right.
it's designed to comply.
Okay.
So
Elisa's question then,
sure. I'm happy to answer that. So, when I first applied for this, I applied for permission to do a 3rd and 4th dwelling, and Billy reached out to me and suggested that might be a use variance, which is not generally allowed under your authority. And I agreed with him, and I tried to think, well, how can we do this? And I remembered that we had done this temporary alteration to the tent bylaw a couple of times, and so I revised my application. And I think that the staff's position on this is not for or against the merits of the application. It's whether or not they consider this to be a use variance, and I think they're coming down on the side that it might be. I'm suggesting it's not. Frankly, I think it's whatever you think it is.
Billy, I saw you put your hand up. Do you want to comment?
Yeah, I'm under the definition of variance. It's with respect to particular land or structures. And I don't think it's necessarily specific. It's not specific to any owner. That would be with respect to the land or structures, regardless of who owned it, would not be able to do this. So given the circumstances, it's very particular to this case. It's not regardless of who would own that land.
I was trying to think back on the 2 tents, the Dreamland and the White Heron. And I think, and I can't remember specifically, but I think that one of the big differences there was that those were more for the public good and the good of the whole entire community. And leaving them up was allowing local theater and programming to continue in the midst of construction or pre-construction or during construction. So it wasn't just we're here, it's just a specific property and a specific landowner. I also I feel for the housing is so tight and tough. But I don't know how we would structure this to, it just seems like it's no matter how we condition it, I don't know how we control like that. Besides, I know that it's going to have the restriction on it for the year-round residency restriction, but I don't know how that I don't know that we want to get into the business of policing who's living in a house and maintain, like keeping the lease and all of that. So I don't know how, I get the argument of year-round housing. I just don't know that how it's, the owner isn't living there and it's not his year-round housing. It's these people that are under a lease. Like what if something happens and I don't know. I just think it's too, for me, it's too far of a stretch, I think. But does anyone have, hold on one second, Amy, hold on. Anyone else on the board have any comment? Mark has a comment.
I'd like to make a question to Steve.
Mhm.
It would appear that after the primary dwelling closest to the street is raised and the proposed secondary tertiary building, whatever you want to call it, goes in, the addition that was proposed on this plan for the one-story, one-bedroom dwelling seems not to calculate into a 20% difference between the primary dwelling and the secondary dwelling.
Yeah, Mark, that's correct. There are two answers to that. One of them is that we would, if we were going to get approval to do that addition, we could potentially require permission from the planning board to get to waive the 20% differential rule, which we have not yet applied for. And I think actually the more correct, more complicated answer is that that rule applies to primary and secondary dwellings, but the structure that would be measured against is both a secondary dwelling and with an attached tertiary. So if you delete the attached tertiary, then it would comply.
Not buying it.
That is an issue that I would have to clean up at the planning board. And if the planning board requires that waiver, then we would either get that waiver or not be able to do the addition. Right. So it's possible that the planning board would say you can't have the bedroom. It's possible the planning board would say you can't do the addition. Both of which are future issues unrelated to here.
Yeah, it's just showing up on the plan. That's why I commented on it.
Yeah, no permission is required from you for that.
No.
It's a planning board issue.
No. But you said you were going to them anyway for a special permit
That's right.
for the property. So why wouldn't you include that in your request for relief?
Well,
Just,
like I said, so
guess
my
it's a strategy
interpretation
thing.
is that 20% rule doesn't apply, but if the building commissioner or the planning board required it, we certainly would
Okay.
apply for it.
Sorry,
Amy,
Madam
you had
Chair.
something to say?
Thank you. One of the things here, like you wrote up here on the yard sale, that does go up and around. On the other side of this is now sort of the new industrial area that there's I think with the change of Glowacky and Richmond and all that, a bunch of people moved in up there. We have the new entry that goes up. And they've already cleared all that property and pushed over to everyone's sort of property line that goes up on that side. So technically the 12 feet wide, we had gone in to say, oh, we're going to potentially do this. Like you had mentioned a couple years ago, we were going to take this. But now some of those persons on the other side that have purchased those properties, they want 6 feet of that. So they technically only have 6 feet of potentially that yard sale to purchase. There's a few other, I'm not sure what the companies or LLC names are that are over there, but there's a few other people that have bought in are over there. Because when you come up over on our side, ours abuts Nantucket Inn and our 12 feet. Nantucket Inn has stated they don't want the 12 feet. So we get to potentially in this get our 12 feet. But on that side, all these other people are like only 6 feet. Because
Okay, that's a good point. So even with the yard sale, it would still be potentially, I mean, if this played out, whatever, but
It might be a 1 foot encouragement if that were to happen.
well, you've got a 10-foot rear setback and you would only have,
We'd go from 10 to,
you'd get 6 feet. So you'd be what, you'd be 3.11
yeah.
feet.
So it would still be curative, but maybe not 100%. But that's the first time I heard that. So that's good to know. Because I was under the impression that the people on the other side had indicated that they were waiving. So
I don't
Yeah,
Sorry.
but I think Amy probably has a better ear to the ground on that issue than I do.
One more thing. It's just, I have video. We've talked to them before about having that property cleaned up. For some reason, it's the only one that, and I have video from just recently of what it is now. And it's definitely needs to get cleaned up. I'd be excited.
Yeah.
But I don't want a duplex. I don't want 8 bedrooms, 16 people plus kid, whatever. It's a great neighborhood for families and stuff, but it's too much. I have a 3-bedroom home, 2-bedroom technically. I have 3 cars. There's other people, same area they all have. It's too much. And there's no off-street parking. We've tried to make it so it was kind of like, wasn't like that because it was. And I just don't know how it would fit. Now, I don't know if you've been in the area. The Gullies did a really beautiful second dwelling in the back for their sons. It's great. We kept I know the houses can change, but it doesn't make everything odd. A long time ago, the fees built, they had, because of the ground coverage, they had to go up. They didn't make something that's great. But to have 3 buildings plus sheds, which aren't gotten, plus all of the cars, it's too much. It's too much.
So, okay, so at this point, I think we've heard from the applicant, we've heard from staff, we've heard from neighbor. There was no other mail on this one, right? I didn't have any, okay.
Madam Chair, because
Mhm.
it's a variance, I assume you know, and the board knows that I need a 4-person vote. My inclination, my hope is that you'll grant the motion, but my inclination would be to withdraw instead of taking a denial if you were heading in that direction. So if you wouldn't mind accommodating, trying to see if there are potential conditions that the board would have 4 votes for, and if not, I'm happy to withdraw because I prefer not to have a denial.
Okay.
Ma-
So, yep,
Madam Chair, I was going to suggest, I really would prefer, I'm not too inclined as it is to vote for the variance, but if you, I would urge you, rather than withdrawing, perhaps to see if there's a way to work this out administratively. If there's any other avenue you can find to get this, so it's not in front of us, rather than having us try to put on conditions. I don't know that I'm ready to vote on any
Mhm.
conditions. I
Okay.
don't know. So if I would be more inclined to continue for a month.
is that
That's just me.
I sort of feel the same way, especially just the
Yeah.
issues that Ms. Manning's brought up. If you could have a conversation with maybe the neighbors and see
Yeah.
about
Maybe
parking
you
and.
know how to call me at my office. Call me in my office. Yeah, that's fine. All right.
Yeah, and if you could, because it seems like there's,
Yeah,
there's some,
I think there are some issues that are outside of this board's issue.
of course,
That we as my client as a landlord and a good neighbor should be addressing. So I'll reach out to Amy to talk about that.
okay, and
But I think that John's suggestion is well taken, and based on sort of the heads nodding, I would take the advice, and I'll ask for a motion to continue until the July 13th meeting.
okay. So would someone want to, Michael will make Steve's motion,
I'll second it.
and John will second. Okay, so voting, Mark, I'm gonna have you vote on this one. Okay. So it's Elisa, myself, Michael, John, and Mark. All those in favor of allowing this one to continue till July 13th, please say aye.
Aye.
Aye. Okay.
All right, thank you. I appreciate the
We'll
board's
see you.
time.
Right, yeah, yeah, sure. We'll just take a quick break. Okay, everybody?
Yeah, 2 more. They could do a lot of different things there. Plan a little planning in the middle of it.
Yeah.
As long as, I don't know.
Yeah.
All they need to do is show us more parking, but I'm not gonna-
session. Right, out of recess. Oh, good. Okay, thanks. So next we have, actually, Paul's not back. We have 0723 4 Harbor Square, Sarah Alger presenting. Hey, Rick, would you tell Paul Murphy we're back on? Thank you.
Let me know when you're ready.
I think we're ready.
Okay. Good afternoon, Sarah Alger. I represent the Old North Wharf Cooperative. With me is Danielle De Benedictis. She represents Charles Johnson, who's one of the cooperative shareholders and the holder of a long-term lease on the dwelling that's about 12 inches away from this proposed project. The purpose of this action is twofold. We're appealing the decision of the building commissioner not to revoke the building permit issued for this project in the absence of an MCD special permit. And we're asking for the revocation of the permit itself. I first want to say that this is not a David and Goliath situation, despite everything you've seen in the press. As far as I'm concerned, this is about NIR retail, which is certainly able to stick up for itself and hold its own, playing by the same rules that the rest of the commercial enterprises in town have to live by. This project is also not a so-called clam shack. It's a full-blown 62-seat restaurant with a full liquor license and an entertainment license that is going to have a significant impact on the surrounding areas, and in particular, the Old North Wharf and Mr. Johnson's dwelling. There have been a series of permits issued for this project. The first two permits were really basically for minor work. They didn't indicate any change in use. One was for kind of minor clean out of equipment. The second was for foundation work. The third permit, which apparently issued at the end of January 2023, was not available. We've been looking for these permits because so much work was being done on this project. We kept looking for the permits. Permits were not available for whatever reason. And plus, the file had been lost. We first heard that a permit had been issued at the liquor license hearing. I went down to the building department the next day to get a copy of it. I was told there wasn't a permit. We kept looking for it. It was finally provided to me the day after, and we appealed within 30 days of actually learning of the permit and being provided with a copy of it. So the big question is, why do I think this is an MCD? Well, if you look at 139.11, it's pretty clear. An MCD is defined as a single commercial structure or use, or a group of commercial structures or uses, which is proposed to be constructed on a single lot or tract of land or on a contiguous tracts of land and held in common ownership or control, meeting in the aggregate any one or more of the following criteria. And the criteria that follows includes things like restaurants having a capacity of rated legal occupancy of 100 or more, marinas, wharves, piers containing 250 lineal feet or more of tie-up space. The property owner is taking the position that the word constructed means that MCDs only apply to projects that are proposed to be constructed as opposed to cumulative uses in existing structures. Well, first of all, I want to give you these pictures of the wharf as it has existed over the last 6 months. To me, this is clearly construction. Even if you took the narrow view of what is construction, the walls were gone, the roof was lifted, there was no floor, the entire interior of the building was gone. So let me get it. Do we know who's sitting or is it?
Sorry, I think the sitting board will be the full, the 4 full members, and then, I don't, Jim and Mark, do you guys have any? Will both of you be at, just in case this gets continued for any reason?
Just want to say I might be conflicted because I did some work on commercial wharf and another wharf for a similar restaurant recently.
Okay, well then Jim, you'll sit on this one, okay? And
I was gonna nominate,
what,
I was gonna nominate Mark, but
why do you think you have a conflict?
no.
I mean, Sarah, how do you feel about Mark's?
I'm sorry. what-
So Mark was saying he feels he might have a conflict because he's done some work for a restaurant.
NIR, yeah.
For NIR. Okay, yeah,
Okay,
then, yeah,
Yeah.
okay,
Madam Chair,
yeah.
as long as we're going to confession here, I was representing a seller in an acquisition where one of your clients was the father to the person that bought it. So if you,
how long ago was that?
over 2 years.
Okay. I don't believe that creates an issue, particularly given the passage of time, but
Okay,
okay,
okay. So that'll be the sitting board then.
all right, thank you.
Yep.
So, so back to construction. I mean, if you took a very, very narrow view of the word construction, that would mean that an MCD would never apply to a building that was already in existence. And that would render meaningless subsection C, which talks about applying MCD guidelines to pre-existing non-conforming uses. You couldn't have a pre-existing non-conforming use that wasn't constructed. So if an MCD is only something that's currently being constructed, that subsection C would never apply to anything. It's just not a logical way to interpret 139.11. So if an MCD is a collection of commercial structures under common ownership and control, then you have to look at, are we talking about just this building or are we talking about a series of buildings? And my belief is that we're talking about a series of buildings. I think at the back of the pictures, the last page is the GIS map. You will see that this particular structure is on parcel 42.2.4, parcel 1. That includes the gazebo where Vineyard Vines used to be. I think that's a clothing store, provisions, the galley gazebo, and the Straight Wharf restaurant. But it also, NIR Retail, which owns that parcel, also owns 422415. Oh, also, let's not forget Crew. And the place where Oath Pizza is, and the High Line. Then there's a connection that goes down Straight Wharf and connects up with the NIR retail property at 42.2.4, parcel 2, which is including Yoshi's, Slip 14, and all the galleries and retail stores, as well as the Anglers Club and some other buildings. So under common control, under the definition in 139.11, are all of these structures and their uses. Now, 139.11C says that pre-existing uses and structures aren't subject to the MCD bylaw until they meet or exceed the criteria after a date in 1979. The property owner is trying to take the position that these uses are permitted and therefore are not pre-existing non-conforming. But when they take that position, I think they're missing the point, or perhaps obfuscating the point, which is that what's pre-existing non-conforming is whether or not this property is considered an MCD. In the absence of 139.11C, the entire wharf would have been deemed an MCD at the time of the adoption of 139.11 in 1979. Instead, it was given grandfathered status. So what's grandfathered isn't the specific use as a restaurant or retail, but whether or not it's an MCD. And as of 1979, it was deemed to be a pre-existing non-conforming non-MCD. So what you have to do is you have to look then at what's happened since that date in 1979, April 4, 1979. And does this property meet or exceed the criteria of subsection B, which defines an MCD? And I think it's really clear that it does. If you look at the chart that I provided now, a couple of years ago, there was an issue with restaurant occupancy. And the Plus department put together a chart of certificates of inspection and what had changed over a period of time. I just went back 5 years. I didn't have to go back to 1979 to find more than 100 additional seats in restaurant occupancy. The changes in this wharf since 1979 have been so dramatic that, of course, it's meeting or exceeding the 100 seats. I mean, the addition of Bar Yoshi alone is sufficient to do that. The addition of this restaurant adds to that, because they're adding, I think, 60 something, a 62 seat restaurant plus their employees plus whatever other occupancy they have. The conversion of the gazebo, which in the 80s was used as a bandstand for musical concerts, has become an enormous outdoor restaurant or bar. When you go down there, there are hundreds of people grouped around that. There have been expansions at the High Line, expansions at Crew, the expansion of the Oath Pizza operation, the extension and enlargement of the Slip 14 property, the addition of those seats. All of this has been done without an MCD special permit. So is this a group of commercial structures on a single lot or tract of land or on a contiguous tract of land held in common ownership or control? Absolutely. Does it meet or exceed the following criteria after 1979? I mean, just take the restaurant, club, and or bar use with a combined rated legal occupancy of 100 or more. 100%. Was it considered pre-existing non-conforming as of 1979? Yes, it may have been, but have those uses in the aggregate as required under subsection C met or exceed the criteria of B above? Again, yes, absolutely. Now, why is this important? Well, it's important for a couple of things. Primarily, I mean, first of all, let's level the playing field. Every other commercial use of this magnitude in town and in the surroundings has an MCD special permit. Every single one. I can't think of one that doesn't. They wouldn't even consider going forward without getting an MCD special permit. So why is NIR retail and Straight Wharf treated differently from everywhere else? Well, the answer is it shouldn't be. And more importantly, this is important because the MCD special permit process gives abutters, whether we like it or not, and believe me, I've certainly been in a position where I have not liked it, gives abutters the opportunity to weigh in and ensure the conditions are imposed that protect them. And those conditions are things like, how is the trash handled? Where is the trash put? Is there pest control? How is the exhaust handled? What about the noise that's generated from all this new equipment? What about bottle recycling? All the many things that neighbors raise when new commercial uses come in to their neighborhood are things that would have been discussed and vetted and possibly subject to conditions in an MCD special permit. In this case, there's been no opportunity for anyone to have anything to say about this change of use. And the only way that you would have known that this change of use was proposed is if you had been able to get a copy of the January 2023 permit, which doesn't apply for a change of use, but simply says under use, proposed use, retail/restaurant. That's really what's at issue here. They should be required to go to the planning board, like everybody else, and get a special permit, get an MCD special permit. And the other changes that are happening on the wharf should be subjected to those same standards. I just don't see why that isn't the case here. I can't figure it out. And I saw that Mr. Burdett at about 20:01 today provided us with a 64-page, or maybe it's 54 pages. I can't remember. I barely had time to print it out. I certainly haven't had time to look at it. They've known about this for almost 2 months. I really would ask that you overturn the building commissioner, and I ask that very reluctantly because I don't generally agree with overturning the building inspector, but I think in this particular case it's warranted for the reasons that I enumerated. I'd ask that you overturn him, revoke this permit, and send this applicant to the planning board for an MCD special permit, as they should have done from the beginning. Thank you.
Thank you. Does anyone have any, do you guys want to have questions for Sarah? Does anyone have any questions for Sarah? Do you want to hear from Rick Bodette
Madam Chair, I'd love to hear from Paul too.
and Paul?
But-
Yeah.
You want to do Rick first or Paul? It doesn't matter to me.
Danielle, you want to speak? Let's hear from. It doesn't look like right now, but why don't we have Danielle go and then Paul and then Rick?
Madam Chair,
Oh,
I just
yep.
want to make a point. that my business is located there and I are not the retail arm, but the boat basin is my landlord. And I don't know if that presents a conflict that they might not want me sitting.
I think you should probably submit. Do you feel that it would create a conflict for you to sit on this?
I don't think so, unless I get a call from my landlord. For this, but no, it doesn't affect my view on it.
So
Well,
you,
I would say that voting against his landlord would be a conflict. I mean, in other words, he could be possibly concerned that the landlord would
Would
be
be
angry
telling
with him. It would affect his lease. I think it's a conflict.
3, 4. So then we're gonna get to a point then, if
We would be at that point.
we
Mark's
will
up.
have, yes, I'm
I'm in.
saying 1, 2. So we would have 4 people at this point. We should have 5 members at the next meeting. Sarah, do you have any?
I would say we should continue the hearing because I think under the state conflict of interest law, which as a former assistant attorney general, I'm very familiar with, there's definitely a conflict here.
Yeah, more than just submitting that form, acknowledging that there's a conflict. I think, and you worked directly for NIR as well? Okay. How recent?
This past winter.
Okay.
Sorry
Okay.
about that.
No, I thought it, but since you didn't bring it up, so yeah, I think we should continue if we only have 4 members at this point that can.
Sorry, can you state your name for when I'm doing the minutes? Thank you.
Attorney Danielle V. Benedictus, 68 Commercial Wharf in Boston. I represent Charles Johnson, who owns the abutting property that's 12 inches from this commercial activity.
Madam Chair.
Yes.
I think we have to continue.
Mhm.
The question is, the testimony that we've already heard. Can we get somebody to Mullins in on that?
I think so. If we have we should have a new member, right? By July 13th, when is the
Yes,
select
we should
board?
have a new full board member by July 13th.
Okay, so that'll give us 5, assuming he doesn't have a conflict. And then, yeah, he could.
Otherwise, I guess
He could.
you just have to redo your testimony.
Right.
Yeah.
You can do that.
I mean, you can do that, but he cannot, we'll see if we can get him to Mullen in.
Okay.
Um,
And maybe Lisa could mull it in as well.
Lisa will not be, she got her application in late, so
Oh.
she is not going to be,
Joining us.
no. So, yeah. So I think we need a motion to continue that. And that'll give us time to read what Rick has submitted and we'll get a new member.
It'll give us time to read it too. I haven't even been served with it.
Okay. Okay, so would someone make the motion to continue? And I guess we will just, so if we just have 4 members vote, right? Because if both alternates are conflicted, and then we'll Mullen in the new full member. Okay. Okay. Did you want to say something before we do this?
Well, I just. What prevents the building commissioner from them proceeding ahead and getting a occupancy permit and opening and.
Are they that close to?
I don't know where they are. Anyway, I think we have to continue.
I think we
so-
have to continue, so.
It's possible we could file a court action asking for a stay until it can be heard, if necessary.
Okay.
It is
Well,
the
it's the applicant has to, they would agree to proceed with 4.
Do you want to proceed?
No.
Yeah, I don't blame you. Okay, so, we're gonna entertain a motion to continue till the July 13th meeting. Would someone make that motion?
I'll make that motion.
And, okay, so, sorry, so,
Also,
Yep.
I just want to mention, I will sign whatever's necessary to extend the hearing deadline because we already are bumping up against our hearing deadline. Because
Okay.
there was an administrative issue why we couldn't be heard last month.
Oh, right.
So I think we're already bumping up against
You're-
it. So I'll sign whatever's necessary.
Yeah, your action your action deadline is July 22nd.
I
So,
think it has to be heard though 65 within.
yeah, no, I know, but I'm agreeing with you that July 22nd is still tight. Okay, so John made the motion, Michael seconded, and so we'll just the four of us, so
Aye.
I,
Aye.
okay, so we will revisit this in July. Thank you.
July's gonna be a long meeting.
Yeah.
I'm gonna bring a tent. Camping. What is the July meeting?
So
July 13th.
we do, yeah. Is there someone here for? Oh, on Zoom, okay. I forgot about Zoom. So we can start, Arthur, I didn't forget about you, I just forgot about Zoom. We'll move on
Understood.
to 0823 39 Monomoy Road LLC, 39 Monomoy Road. Attorney Arthur Reed for the applicant, and you have the floor, Attorney Reed.
Thank you very much. This is an application to construct alterations to a pre-existing non-conforming single-family dwelling. The structure is on a lot that was created pursuant to an 81L subdivision, so it has the status in all respects of being a legally existing non-conforming structure. My client is now constructing or proposing to construct certain additions to the structure, which will involve eliminating an existing non-conformity in side yard setback, will increase the front yard setback from the present 9.6 feet to 9.9 feet, and will keep the ground cover, the existing ground cover, exactly at the level that it's at right now. Accordingly, we think that this is a classic case for no new nonconformity being created and the existing nonconformity not being increased, in fact, being reduced. And we would therefore ask for a special permit under 33A for the alteration of the structure as indicated, and also a special permit under 33A4 for removal and reconstruction of the portion of the non-conforming structure situated within the front yard setback in accordance with the plans that have been submitted to you. We can go into more detail as to the project if you wish, but I think that's what it boils down to.
Thank you, Arthur. Does anyone on the board have any questions for Arthur at this juncture? No. Okay.
I do.
Okay.
Not for Arthur, for the chair.
Uh-huh.
I just realized that my office was involved in this sale,
Okay.
and I don't know the buyer. I don't know anything about it, but I just want to bring that to your attention. I know very little about it, and I don't have any ongoing business with anyone involved in it or the neighbors, etc.
How long ago was that?
It was maybe a year ago.
Arthur, do you have any reservations about Michael participating in this? And
No, I don't. I think any involvement he had was with the prior owner. not with the present owner, the principal of 39 Monomoy Road LLC is my client, Brian Fogarty. And I don't believe that Mr. O'Mara and he had any dealings directly.
Okay, great.
Wait, is Brian Fogarty the current owner?
Is Brian Fogarty is the current owner?
Yes, but he's the manager and principal owner of 39 Monomoy Road LLC.
Okay, so Elisa, you have a direct conflict, do you feel?
Yes.
Okay, so then Elisa is gonna recuse and we'll bring you back in when.
Thanks.
And so then we have 1, 2, 3. Okay, so then it'll be the 2 alternates and the 3 regular members sitting on this for your board. Okay, Arthur?
That's fine.
Okay. Okay. Is there anyone in the audience who had anything on this one? No. Okay.
Madam Chair, were there any, through you, staff, were there any letters or phone calls or emails or anybody?
No mail on this one.
Staff did not receive any emails, phone calls, any correspondence with anyone else than Mr. Reed's office.
Based on the application and the increasing conformance with the front yard setback, I don't at this time have any objections or issues. Okay. Mark, do you have any?
Madam Chair, may I
comments?
just make one
Sure.
more point?
Of course.
I meant to mention, not that it changes anything, but it should be, we'll be putting something about it in the decision. The site is constrained by wetlands. And that's the reason why we're keeping the house in approximately the present condition, regardless of the work that's being done. We've been to the Concom, have Concom approval, and that is a constraint on the site, and therefore part of the reason as to why we're doing it exactly the way that we are.
Okay. Sure, Mark.
Arthur, the proposed shed appears to be less than 200 square feet.
I'm sorry, I couldn't understand.
He's
what
asking
Mark said.
about,
Ground cover, you put in another structure on the lot. The proposed shed, if it's less than 200 square feet, pardon me, doesn't constitute additional ground cover. And I can't read the fine print here. Looks like 196.
No, there's no additional ground cover.
oh, yeah. I see.
The ground cover that is proposed will be exactly the same as what's there. Things are being moved around on the site, but we're being very careful to keep the ground cover at exactly the level that it now is, with no increase, and we're not asking for any relief with regard to ground cover.
So the shed is going to be done under a zoning permit application and will not constitute additional ground cover. That's what you're telling me.
Right. Yeah.
If there's no other comments or concerns, would someone want to make a motion for this one?
I'll make a motion to approve the request, the relief as requested.
Okay. A second?
I'll second.
And Mark seconds. Okay. So all those in favor, and everyone at the table is voting. So all those in favor, please say aye.
Aye.
Aye. Okay. Did you vote? Yeah. Okay. Okay.
Thank you very much.
You're welcome. Thank you, Attorney Reed. Okay, we can move on to 0923 52 Warren's Landing Road. Attorney Reed presenting on this one as well. Attorney Reed, you have, oh, Elisa, you're coming back. Okay, This is Edward V. Lahey Jr., trustee of the Boathouse Realty Trust, 52 Warren's Landing Road, and attorney Arthur Reed is presenting.
Great, no comment there.
Okay. So Arthur, you
Thank
have
you.
the floor again.
This is an application involving moving an existing very small cottage, one-bedroom structure that has existed for many years on this property on Nantucket Harbor at 52 Warren's Landing Road, which has belonged for a long time to my client, Ed Lahey. Working with his architects and his surveyor and wetland specialists, they've determined that it would be appropriate to move the house away from where it is currently situated, which is right on the harbor. It's in a position where, although the rate of erosion there is relatively slow, it is immediately adjacent to the beach. And as a matter of dealing with coastal resiliency issues, as everyone is supposed to be doing these days, they want to move the structure to a point on the eastern part of the lot, farther away from Nantucket Harbor. The wetland constraints are not only the location of the harbor, but also a wetland to the east and southeast of the property. And in so doing, they've obtained Concom and HDC approval for the structure to be moved to a location which would wind up having a 24-foot setback from Warren's Landing Road and a lesser setback from a unnamed way running along the easterly side of the property, basically in the wetland. The point here is that, strictly speaking, the structure is now conforming as to front yard setback, because even though it's closer to Warren's Landing Road than would be permitted, the unconstructed way on the easterly side of the property technically provides front yard setback. And under the bylaw, that's allowed to be counted. So we're basically creating a new nonconformity by moving the house to this location, and therefore we need a variance. The variance, I think, is very well justified by the fact that we are dealing with wetland constraints. First of all, the desirability of moving the house further away from the coastal beach on the westerly side. And then in so doing, we have to maintain the required setback, which the Concom has reviewed and has approved for the relocation of the structure, so that it will be about 24 feet at its closest point from Warren's Landing Road, 35 feet being the required front yard setback in this Lug 3 district under the zoning bylaw. Again, with the wetland factors affecting soil conditions and topography, the board has traditionally been receptive to moving structures and granting variances in this situation, because I think they're very clearly legally justified. As I said, we have HDC approval, we have Concom approval, and I think that's it, unless you have any questions.
Okay, thank you, Arthur. Is there anyone in the audience to speak to this one? No. No. Okay. Do anyone have any questions on the board? Have any questions for Attorney Reed about this one? No. Yep.
I do not.
Sure.
The house is going to be.
Jim, I think you need to put your microphone on.
The house is actually being moved or reconstructed, or demolished.
Combination of both.
I think looking at the application and the proposed work and the HDC approved, Concom's approved. I think this request squarely fits in to what the variance is designed for, and especially what we've done in the past for homes in this area and in Sconset that need to be moved away from eroding bluffs or coastlines to retain the ability to use the house and keep it viable as long as possible. I don't have any objections to this request.
I do have
I
a
sh-
question.
All right, hold on, Elisa
Oh, sorry.
first and then Jim.
What is the foundation? What is, there'll be a new foundation, Arthur, or Madam?
Are you
Chair?
asking about if there's a basement or just what it's going to be on?
Is it on piers or? Okay, let me ask this. Will you then apply for a building permit? If
Well,
we,
we'll obviously have to apply for a building permit to
but if we approve,
relocate the
this-
structure.
okay, and then what will the foundation be? Will it be piers? Will it be block? Will it be forms? What will it be?
I believe it's going to be piers. I mean, we're dealing with wetland constraints here, and we need to comply with the requirements in connection with floodplain, including the elevation of the structure to the of the first floor of the structure, as is required in under floodplain requirements.
Yeah, we're blessing, if we do grant this,
Yeah.
we're blessing a variance from the front yard setback requirement
Mhm.
because it's going to now be in the setback
Yeah.
on the front, but they still, that doesn't, we're not giving them any, waiver from any other construction regulations or requirements, and they'll have to follow all of that
Mhm.
with those appropriate
Mhm. Okay.
entities. So,
Okay.
yeah.
Yep.
So that's sort of outside of our.
What is the variance again?
So the variance is, the request from the applicant is, it's basically in the last sentence on page 76. The applicant requests the granting of a variance from the front yard setback requirements of 35 feet in the Lug 3 district to enable the siting of the relocated house as close as 24 feet from Warren's Landing Road. And I believe the applicant stated that they already have Concom approval for that siting as far as wetlands
Yes.
go. So they've already gone through that process and HTC.
My only reservation on this is I was surprised. I didn't know there's erosion in Nantucket Harbor. But when I looked at these two pictures, I don't really see a lot of erosion in this case. Usually
What
we
page
see
are
a
you
lot.
looking at?
This is in
Last two pages.
The last two pages of the packet?
yeah, which maybe I'm wrong. This is more of a subjective
It's not the last two.
analysis.
Madam Chair, if I can speak, this was on the
Yeah.
staff report.
Yeah.
Oh, sorry.
I noticed after I saw the printout that is not what I was looking at. It's much different looking when you see it on a computer screen, because there was a lot of
Okay.
green behind that house that's turned to sand. And that's what I was trying to show.
Mhm.
And it didn't really show up because the GIS aerials are just very granulated,
Yeah.
pixelated photos.
Okay. So my point was, if we're creating
No, no,
a
no.
non-conformity based on something that doesn't really exist, but
Mhm.
I'll go off what Billy clarified.
We obviously also are dealing with sea level rise issues, which we are being confronted with constantly, and that is a further reason to deal with the location of the house, as well as elevating the house and getting it into a more appropriate location on the site.
Is there
Yeah.
a way of relocating it and conforming
Well,
and not
No,
needing
No,
variance?
no,
no,
but also I think,
because of what.
go ahead, Arthur.
No, the wetlands, we have gone as close as we possibly can, granted the wetlands in connection with the notice of intent to the Conservation Commission.
And are you increasing the square footage?
No,
So the GIS pictures, I was relying more on the plan from Jeff Blackwell that's dated May 10th, 2023, that shows corner of the deck is right up against that coastal bank. So,
Yeah, I don't see any other benefit for the applicant.
no, I mean, nobody wants to come and ask for a variance.
Yeah.
So, would someone, unless there are any additional questions, and I don't think I'm seeing any, would someone make the motion to grant the variance as I read it, a variance from the front yard setback requirement of 35 feet in Lug 3 district to enable the siting of the relocated house as close as 24 feet from Warren's Landing Road?
I'll make that motion.
Okay, so Elisa makes the motion.
I'll second it.
John seconds it. So then we have 1, 2, 3, 4, 5, 6. So I think we'll vote. We'll vote this. So Jim, you're going to sit this one out, okay?
Yep.
Okay. So all those in favor, Mark, you're voting on this one. Please say aye.
Aye.
Aye. Okay. So that passes unanimously. Thank you.
Thank you
Attorney
very
Reed.
much indeed.
So next we have 1023 Nantucket Cottage Hospital, 16 Vesper Lane. Yep.
Madam Chair, in the interest of disclosure, since everybody seems to be mentioning potential conflicts,
Mhm.
for the original application, the one that we withdrew
Mhm.
today, before I was appointed to the board, a neighbor had contacted me and asked me questions and was not was concerned with it. I don't know if anything of that happened. I don't know if that qualifies. I told that neighbor that I would likely be sitting on the Board of Appeals. I don't know if that qualifies as conflict. But again, as long as we're doing the confession.
Yeah, I
here we
don't
are.
think it does, but I would ask the applicant, do you have any concerns about Mr. Brusher's ability to?
Thank you,
sit?
Madam Chair. Rick Bodett for the applicant. As long as John thinks he can be objective, then I don't have an issue with it. And
Anyone else have a confession?
I had an appendectomy there.
It's all coming out, Madam Chair.
as long as we're coming clean, I'm on the abutters list. So I have also talked to one of my neighbors. about this.
Okay, so I think it seems like we're good on conflict, so it'll be the 4 sitting members, and then I don't know, probably will Jim vote on this one, unless Mark, do you? All right, so Jim, you're on this one.
Thank you, Madam Chair.
Mhm.
As I said, Rick Bodett for the applicant, Nantucket Cottage Hospital. Tim Sullivan and John Tewig are on Zoom as well to support me. Brian Sullivan is here as well. He's the chairman of the Affordable Housing Trust Fund. And I assume he's in favor of this. But we're talking about 16 Vesper Lane. This property is currently owned by Nantucket Cottage Hospital. It's an oversized lot in the CN district. It's almost 2 acres in a district that only requires 7,500 square feet. The property, and the reason we are here is because the property is non-conforming as to frontage. That big lot in the back on the site plan has no frontage whatsoever. Neither does the property that the trust owns to the north of it. And it's accessed through an access easement through the Coast Guard property. We're really excited to be here because this is something that the town and the hospital and the trust have been working on for some time. And we're hopeful that it'll solve some of the hospital's housing problems and hopefully some of Nantucket's housing issues as well. Essentially, the proposal before you is a variance seeking to create additional lots on 16 Vesper. And those lots would also not have frontage, obviously, because the original lot does not have frontage. The trust owns 18 Vesper, which is the property just to the north of this. The hospital owns 16 Vesper. So the proposal is to divide 16 into 4 lots, one with the existing housing structure on it that the hospital will continue to use. The other 3 lots created are oversized lots, 15,000 square feet. But again, they don't have frontage. They would be accessed through an access easement. Those 3 lots are proposed to be conveyed to the Affordable Housing Trust in exchange for the Housing Trust conveying 18 Vesper to the hospital so that they can use that for housing. That's essentially the proposal. We think it meets the standard for a variance. Certainly the applicant and the Affordable Housing Trust would have a substantial hardship if they wouldn't be able to do this. If you literally interpreted the bylaw to require frontage on all 3 lots. It's certainly owing to the shape and uniqueness of this property. It is a landlocked property. It's very rare to have a property this big. I can't think of another one, property this big without frontage. Indeed, if it had frontage, we could probably create 10 lots out of this. And obviously granting the relief won't result in a substantial detriment to the public good. I think to the contrary, there's a real public benefit here to allowing this variance and allowing us to convey it to the Affordable Housing Trust. And obviously it won't nullify the intent of the bylaw. The intent of the bylaw, as you know, is in part for the welfare of the inhabitants of Nantucket. And we think that this proposal will be good for the inhabitants. So happy to answer any questions you guys have, and we hope you'll grant the variance.
Madam Chair, may I ask a question through you to staff?
Of course.
Do we still get planning board recommendations in CBA applications?
We do. I did not actually, I don't think I heard anything from the planning board on this one.
Okay, Madam Chair, through you, I ultimately, I think I'm inclined to vote for this variance. However, I'll be the first to say that this is something that I would certainly defer to the planning board, or like to see the planning board have comments on any types of restrictions or recommendations that they would have relative to this, since they normally deal with these types of subdivisions. They may come back with none, which is fine. But unless there's a burning need to get this done, I would love to know planning's 2 cents on this whole thing.
I think that makes sense. Do you have the easement with, were you looking for an easement with Coast Guard, or did that get resolved?
No, we have an easement with the Coast Guard. They originally, I think it was in, we filed this a long time ago. They originally objected. And then, since then, the reason we haven't come back and actually open the hearing is because we're negotiating with them. So we do have an easement already. We did get confirmation from them actually today that they're fine with this. We have signed an agreement with them saying that they're not going to object. And also one of their only conditions was if there's anything that's constructed, they want to instead grant us a separate temporary easement to the west for just construction purposes, so that construction trucks aren't coming through the Coast Guard property. That was their only concern.
Okay.
Madam Chair, another question for you.
Sure.
Rick, the relief is so that you guys get 3 validly buildable lots, right?
The relief is to create 3 new vacant lots in addition to the remainder, the lot that we'll keep.
Right, but that that lots, what are they? 3A, 3B, and 3C are all separately marketable and buildable and can be as though they were a lot of records. So
those are the 3 lots that go to the Affordable Housing Trust.
Got it.
And I think that the I know that the trust isn't sure what they're going to do with it yet, specifically, but I think the chances are that it's going to be used as one lot. But having 3 lots gives them the flexibility to get the number of units that they want to get there, whatever that is.
And one more question through you, Madam Chair, to the applicant. And have you gone through for an A&R yet?
No,
Okay.
no,
Fair
no,
enough.
we haven't. And you know, through Madam Chair, through you, you know, I know that, you know, usually the zoning board asks for the planning board's opinion on it. I know it's been vetted for a year and a half through the town, through the planning office, through the plus department.
Got it.
And it certainly has their blessing.
Right, because you were supposed to be before us a while, like a month or 2 ago, right? And then there was an issue that came up and then that's been addressed.
Yeah, I
with-
think it was
through
you know,
plus.
Yeah, I want to say it was maybe December. We were originally.
Was that when it was? Was that long ago? Okay.
I think we continued it for a long time. Yeah. And I think that whole time, the issue that came up was the Coast Guard. And that's what we've been working to address. And then more recently, the trust came to us and asked to make it 3 lots instead of 1, for that reason I just mentioned.
And was the plan always to give them 1 lot?
The plan was always to give them the exact amount of property we're planning on giving them in this application. The only difference is you'll notice we have, you know, sort of dotted lines creating lots. And that's why we're in front of you to create the 3 in case they want to have 3 to have the flexibility to either have 3 structures or 1 bigger structure there.
Okay. Sully, did you want to speak?
Yeah, if I may.
Yeah, just identify yourself.
Yeah, Brian Sullivan, Affordable Housing Trust. So my initial comments are, we're excited to work with the hospital. This has been a long road in acquiring the property from UMass. And then being to get to the table with the hospital to kind of create both an affordable housing need and then a hospital need. They have worked very hard with the Coast Guard on our behalf. And to get to the table here, we recently worked with the Plus Department on the concept of bringing forth the 3 lots. RFPs that we have out now at the trust, we are working with existing zoning and not looking for bonus count units, bonus square footage, et cetera. So in this scenario, the lot count number and the unit count number were critical to us in our request with the hospital to bring forth the plan this way. So again, the plan as drawn was recommended to us by the officers at Plus, and it's why we're here today in conjunction with the hospital. So thank you for having us.
I have a question.
Sure, Elisa.
If this became the 3 lots, would each lot only be allowed to have 1 dwelling on it?
I think part of what Sully is talking about is that having the 3 lots gives them the maximum flexibility to do what they want to do as a matter of right. So no, I think the trust is able to put as many dwellings that could go on the property in CN. They could do any number of things, but I think the idea of having 3 lots is to give them the ability to have, more units. And when I say units, I assume I'm assuming they'd be apartments, but again, I don't know that they have a specific plan yet.
To that note, we don't have a specific plan. So we would put out an RFP to somebody, to anybody, to everybody, to say that within zoning, this is what you're allowed to do. Please give us the, proposal that's going to fit the requirement for unit count, affordability, who it's going to service, whether it's in conjunction with the hospital needs or not, et cetera, and put that out. And our effort will be to try and meet the timing of whatever the hospital's project is so that both things can happen near the same time. The trust has not met in a way to put together the RFP for what it would be. And it would be within what the zoning would allow. We wouldn't be looking for 40B. By the creation of the 3 lots and whatever the zoning is, that's how we would put it out for a request. Does that make sense?
So you won't be coming back to us for any more variances on this property when it's 3 lots?
I don't, yeah. I don't know why we would.
To quote Susan, nobody wants to come here for a variance, so.
Yeah.
Yeah, I don't see, I don't know any reason that we would.
Madam Chair,
Sure.
to get back to John's initial question regarding the planning board's take on this
Mhm.
application. I just heard from Leslie, and she'd love to come over and throw a plug for the applicant. However, she's got a special planning board meeting this evening,
Mhm.
and she's already on her way home.
Okay.
So
Okay. So I think
Madam
that,
Chair.
yes.
I was gonna add in on that as well, because yes, the first application was received in December of 2022. So it has been in the office for a while, and I'm sure Leslie has a feeling on it. And I don't know if she had sent it out to the planning board to get any comments from them. So I have a note to follow up with her on this.
Okay. John, for what you were, I mean, it's nice to hear Leslie's support.
one
Yeah,
last thing.
sure.
She said that she would be happy to come next month if
Okay, if we wanted to
we'd like
continue.
come.
I was just curious, like what you were thinking about for conditions, or you're just looking for like guidance on something that they normally
I
would.
think I was looking more so for guidance, because I don't, I mean, I suppose you could do conditions if need be, but really, I mean, we're trying to, the applicant is requesting effectively 3 buildable lots.
Mhm.
And that's, and if they can, hypothetically, if they constructed a road through here, they could get 3 buildable lots. They don't
Mhm.
need to see us. So instead of a road, they're just doing an easement.
Mhm.
So I get it. I was just more curious about what planning would say about this, because they're, doing an AR subdivision without doing an AR subdivision by doing it by virtue of an easement,
Mhm.
which if that works, that's fine. I mean, but I think it might behoove us just to hear what they say.
Madam Chair.
Mhm.
So I just want to address that a little bit. I don't think we can we would have come in to do an AR subdivision. That's a much easier process. I think that's a slam dunk AR 4-lot subdivision, but we can't. We don't have, I think we would overburden the easement we have if we specifically applied for an AR subdivision potentially. And I don't know, I'm unaware of any AR subdivision that's created on a landlocked lot. In other words, like I said before, if we had even say 20 feet of frontage on Vesper, we just make that a roadway and create lots off of it. We also looked into doing a rear lot subdivision of this, and that doesn't apply in this district. So we looked at all the other options, and this was the only way we could come in and create the additional lots. So. No offense, by the way, that I'd rather be at the planning board.
That's fine. So I'm trying to think what kinds of conditions you're thinking about. Oh, you just are saying you don't know because there might be conditions we don't know that.
I don't know. I would consider it part of the due diligence just to make sure.
Yeah.
And again, this is not something we see very often. And this, as Rick, I think correctly said, if there was a way for them to get to planning, they would.
Yeah.
And, but they can't. And so this is not something in zoning that we see very often, if ever.
Oh, it's for the community, obviously.
Mhm.
And, if the board was so inclined, we could continue it to next month. And maybe have Leslie come up with some conditions that would be appropriate, parking, where you can't park.
Yeah, that's the only one I was
Common
thinking.
utility,
Yeah.
All the utilities going to be in one location.
No more
Uh,
variances.
Yeah.
Well, right, typically, the decisions we do will say something like no, no addition, they'd have to come back to us, or I don't know that we would want to say no other variances. We wouldn't want to preclude them from asking for relief, but they would have to come back to us for any changes.
No, I tend to think, again, ultimately, I'm leaning in favor of this.
We just want more information.
And the idea is that they should have, to have 3 lots to do with sort of unrestricted lots. Where they can do whatever they want.
Yeah.
So that they don't have to continue to get variances.
Once it's deemed a buildable lot, then they would be able to operate within the zoning code, and then anything that
Right.
I think
was
they're free, yeah.
anything that then was additional, they have to, or anything that was outside of the code, they'd have to come back. But I think that's why you're looking for some guidance,
Planning
right?
board,
Because
yeah.
you want to make sure that we're not missing something.
I agree.
Right.
Okay.
Do we need to set up not even a homeowners association, but make sure that the easement spells out that they're going to share in roadway expenses
And sewer, things like that.
whatever.
Well, then why don't, it seems like those are valid questions that you guys want answers to. So I think if Leslie is so inclined
We
to,
need some help.
yeah,
And
with some
we're headed to
detail.
yes.
Yeah,
Uh,
yeah, that's what it sounds like. So why don't we make a motion to continue, and in that time, we can take Leslie up on her offer so she can talk to us and get some feedback from planning if there are any conditions typically that they would put on a similar type.
And there's nothing that forecloses the attorneys from doing a draft of the conditions.
Mhm.
Easy enough, sure.
Yeah.
Yeah, we're used to that.
Okay, so would someone make the motion to continue to July 13th?
I'll make that motion to continue to July 13th.
And Michael seconds. Okay, so we're gonna vote Elisa
Aye.
over. Well, we can just all vote. So
yeah.
Lisa over. So all those in favor of the continuance, please say aye.
Aye.
Aye. Okay, so we will see you next month.
All right, thanks a bunch.
Okay. So we have just before we end, an announcement that Libby should be appointing, I don't know when she does that, but soon. Now,
I don't either. That was just explained to me by Leslie
Yeah.
this morning, but essentially the zoning administrator duties are covered under land use, the contract of the land use specialist. So moving me and Megan in is sort of the simplest
Yep.
maneuver, given that Andrew's leaving.
yeah, so Billy and Megan are gonna be our zoning administrators moving forward once Libby makes that appointment, which you've already been doing the job pretty much.
I've been helping, and a lot of my time's been spent with HDC too, but in talking with Leslie, I'm gonna be devoting a lot more time to ZBA, which contrary to a lot of lawyers in here, I prefer to HDC at least.
Okay, well, welcome aboard.
So Susan, do we need, once Libby appoints them, do we need to ratify it as well?
We don't, we used to, but it turns out at some point there was a discovery that the bylaw and the charter were at odds. And so it's town manager or whatever appoints, and when it wasn't best practices, because then we're getting into hiring and that kind of thing. So which is
Makes sense.
not our purview, and I don't want it to be our purview. So it's,
It makes sense.
yep. So, so that's that for this month, I guess. Look at this. We're finished like 20 minutes early. Good job, everyone. So we will have a new board members. I don't know when the appointments are, but it's.
For the next meeting.
Joe Markham.
Mhm. Yeah, I don't know if that was approved yet or not, but I don't know when the board, when, I know they looked at, I think next week is actually when the select board decides, right? Am I wrong on that? It doesn't matter. So that's it. That's everything that's on our agenda for today. So we can adjourn if someone wants to make that motion.
So moved.
Okay, and someone second? Okay, so all those in favor of adjourning, say aye.
Aye.
Aye. Okay, great. Thank you, everybody. Yep.